session of the London Financial Regulation Seminar, which is an intercollegiate and interdisciplinary group of experts that includes other academics such as Charles Goodhart, who is in the room, and Jeffrey Wood and others from the Bank of England, the PRA and the FCA. The London Financial Regulation Seminar is currently held at CCLS, the Centre for Commercial Law Studies, and I am delighted as director to be the head of the London Financial Regulation Seminar with Daniele D'Alvia as the deputy head. Today we will have a session which has been in the news for all the wrong reasons quite frequently in September and since September. And the title of the session is LDI Strategies, Liability-Driven Investment Strategies Crisis, and the Pensions Regulator on Trial. In this session, we will have both papers as well as submissions to the House of Lords Industry and Regulators Committee and the Work and Pensions Committee of the House of Lords by both Professor Ian Clacher and Dr. Keating. Ian cannot join us today, but Keating will be presenting through his slides their joint research and thoughts. And then we will have as discussant Professor Bernard Casey. Let me just say a few words about the two authors of the papers and submissions that Con will be presenting, as well as a few words about Bernard Casey. So Professor Ian Clacher is Professor of Pensions and Finance, as well as Director of the Centre for Financial Technology and Innovation, and a member of the UK Centre for Greening Finance and Investment, where he leads the Pension and Asset Management Hub. And he's an expert on pensions and retirement savings. Dr. Keating, who is a retired financial analyst, is currently the chair of the Bond Commission of the European Federation of Financial Analyst Societies, EFAS, and his professional career began as a merchant banker and ended as the head of risk management for a major international insurance group. He headed bond trading at First Boston, Credit Suisse, First Boston and Bankers Trust, and was a portfolio manager for both equities, bonds, and derivatives. And in this latter role, his clients included the NATO Provident Fund, Sigmund, and as well as the government of Singapore, Kuwait, and Taiwan. And Professor Bernard Casey, who retired as an academic in 2017, worked in different universities and research institutes in the UK and Germany, and he spent time as senior economist at the OECD and consultant to the European Commission. And again, both like Con and Ian is an expert on pensions, retirement savings, and the economic implications of societal aging. So this has led the three of them to the field of social and responsible investment. And they will be discussing today the extent to which this liability-driven investment were anything but responsible. They exhibited the features of a run, as they will explain. Just very briefly, over the past decade, pension funds have turned to these so-called liability-driven investment strategies, better known by the acronym LDI, to help match their liabilities with their assets. And this strategy was at the center of the recent industry turmoil in the pension fund sector in October and September 2022 that prompted the Bank of England to intervene via a selected round of quantitative easing, coinciding with the time which the Bank of England is also trying to tighten policy. So also an instance in which, for financial stability considerations, the bank was called to do one thing and the opposite for the purposes of keeping inflation under control. But back to LDI, which is the subject of today, the presentation will call these LDI strategies into account and also will consider the role of the pension regulator, which appears to consider itself a victim, they argue, instead of the perpetrator, they argue, of the assault on the guilty party that was the one of the causes that triggered the crisis in the sector. So without further ado, I'm thanking very much our distinguished presenters and discussant. I will now mute myself, give the word to Dr. Keating, to Con, and he'll have 25 minutes to present his thoughts, and then we will have 15 minutes by Casey, and the rest will be Q&A, which will be maybe Professor Charles Goodhart can have one of the first questions and comments, and then Daniele D'Alvia, I know, will have another comment. So, Con, if you want to share now the screen, you have co-share rights, and if not, we can help you. I will mute myself.
Right. I now have to find. This is right. This is work which Ian and I have been doing jointly. Ian first started work on LDI some 17 years ago. My own track record runs back to before it was first created. What I want to focus on today, given that I am talking to a commercial law group, are some of the legal aspects and some of the legal questions which we think surround LDI. And we will also, of course, touch on much else. This very first slide, I first used 10 years ago. And the surprising thing is, one, it's rather amusing. Two, though, is that we are 10 years on from the first time I used it. And in talking to rather a lot of trustees over the last couple of months, unfortunately, the degree of knowledge and degree of understanding of what was being done was, well, let's be generous and say lacking. There's an argument being used that no one could have predicted this. That's actually not true. I've just come from another conference where I heard Fiona Frobisher from the Department of Work and Pensions say that this was a black swan event. The answer is it wasn't a black swan event. LDI worked exactly as it said on the tin, and that meant that we finish up with collateral calls, and those collateral calls triggered an endogenous risk spiral, to use John Danielson's favorite language. The thing which is really rather odd is how little it took to do this. In theory, the market had buffers sufficient for 100 basis points moves. These are what their stress tests were supposedly based on. Those are exercises in comparative statics, and that unfortunately is wrong. It's just the wrong way of approaching these things. If we are going to model this type of situation, then we actually need to have models which consider the risk dynamics. This slide shows the returns for two index-linked gilts which span a 15-year maturity, and for the 15-year zero coupon, which is a good proxy for the duration of most closed pension schemes. And you'll see that the moves which triggered this were really very little. On the first day, the Bank of England shift on announcement of sales of 80 billion from the QE portfolio, we saw 2.5% drop in price. That's about 20 basis points in yield, a little under. And no movement at all in index-linked gilts. Then on budget day, we saw a similar order of magnitude move in the 15-year conventional, and 3% moves in linkers. Now, one of the things to understand is that linkers are more volatile than their fixed income characteristics would have you believe, and that the role of inflation in their pricing cannot account for the level of volatility that we see. And Ian and I are trying to work on some models which will account for concentration in the index-linked market. over 80% of index-linked gilts are owned by pension funds. So the ILG selling in this case can only be pension funds selling gilts, and that means LDI portfolios in these circumstances. That's the order of magnitude. The surprising thing is 37 basis points over 2 days is sufficient to trigger the self-perpetuating spiral. And without Bank of England intervention, there would have been no stop within reasonable distance. So comparative statics is what people have been using, should be risk dynamics. Let's just go to the heart of the problem. And the heart of the problem, the motivation for LDI is accounting. And this is a very simple stylized pension. Single contribution, single lump sum 40 years from now. That is the natural rate of amortization of a contribution of that amount to grow to be 100 in 40 years' time. The accounting standards use not that natural rate. They use mark-to-market rates. So I've illustrated this with three possible paths for interest rates, which are the discount rates to be applied to these liabilities. This first one is a rate which starts at 8 and trends down to 2 over the 40-year term, which is not dissimilar from what we've actually seen over the last 40 years. It has a 10% volatility. You will notice that it's all over the place. And that volatility is what was of concern to pension scheme managers and their sponsors, an accounting standard which brought the deficits, real or apparent, onto company balance sheets. That's actually one where the true rate here, which is 5%, is simply 5% flat, but volatile. Again, it's a mark-to-market problem. It still creates volatility, which is problematic. And that's the final third variant in there. Rates in this case start at 2% and decline over the 40 years to 8%. And you'll see again, we get just different forms of volatility and problems in terms of accounting. Now, the point to note here is that those discount rates do not actually affect the final benefit payment. They merely determine the path to it. And that is one of the questions I will ask the legal beagles to think about. And so I hope you can see that again, and I'm sorry for the interruption. What's going on? Can you hear me?
Yes, we can.
Yeah, thanks. Let's just explain what's being done with LDI. It's very common to present liability-driven investment as if it is matching of cash flows. It isn't. What liability-driven investment is concerned with is matching the valuation of liabilities with the valuation of assets at intermediate points in the development of the pension scheme. So matching the variability of liabilities with similarly variable assets. And to the right here, I've just stylized this, a certain amount of liabilities and a certain amount of assets. And the first thing and there's a deficit here, the assets are worth less than the liabilities. That brings an immediate consequence. It means that if you are trying to match the variability of the liabilities with assets, your assets have to be riskier than your liabilities in order to do that. A second objective was later introduced into liability-driven investments, which was to repair the deficit. And to repair the deficit, then you require your assets to become riskier still. Now, the way that people chose to do this was to lever the asset portfolio and divide the portfolio into assets and growth into matching and growth sub-portfolios. The question then, and this leverage was achieved using interest rate swaps and repo, and we will talk about the legality of those separately. But there's a first question for the lawyers in the audience. As I have always understood it, a trustee's responsibility was to be concerned with the benefits, and being worried about how you get there is at best a second order consideration. And if getting there involves a process such as LDI and the matching of one and the other, and that has a cost, is that not in fact a breach of fiduciary duty? This is just standard. This is just standard asset and liability management. Here we show business assets and liabilities. The main difference between standard asset and liability driven management is that, of course, companies have equity, and standard ALM is concerned with the protection of the equity of the business. Note that assets in a business which is solvent are greater than non-equity liabilities. Okay, then the firm can indeed take and use leverage in that circumstance. With assets which are greater than the liabilities in amount, we can actually manage and match the non-equity liabilities with assets and leave a surplus to pursue growth, which of course is the purpose of most companies. But the pension scheme regulator looks to scheme funding, the assets and liabilities just of the scheme, not to the sponsor covenant, not to the sponsor's requirement to support the scheme. The scheme has recourse at all times to the sponsor. This has actually found expression at one point in time, back in 2011, as funding trumps covenant. We translated that to being, it's no different from saying that seatbelts trump brakes. The regulator does not consider the sponsor's covenant to be an asset of the scheme. We think that there should be a holistic view of risk, and what that means is that you should be looking at the middle balance sheet shown here, which is pension liabilities, equity, debt, and business liabilities on the one hand, and pension and business assets on the other. And the risk exposure is the aggregate of corporate debt and business liabilities. And you will find that there are risk exposures within the pension scheme, within the pension scheme's valuation process, which are actually naturally offset within the company. For example, pension schemes, the liabilities increase as rates decline, but most companies are more profitable when rates decline. So there's a degree of natural offset there, and there are others that are available. The point is, interest rates do not figure in the determination of pensions ultimately payable. They determine, as I showed earlier, a trajectory. So the interest rate risk, which is the predominant risk being hedged in LDI, is a perceived risk, not real. Those rates merely determine a present value. Now, in and of themselves, the variability of the intermediate valuations do not matter unless we base decisions upon them. Now, the regulator bases decisions upon them and can demand deficit repair contributions. The problem with that and the problem with LDI is basically that we are making the mother of all decisions to hedge and operate on each and every valuation. That is staggeringly costly. What it actually does is introduce a dependency or a risk on the performance of gilts into the scheme. Schemes will gain when rates decline and lose when they rise. And that is exactly what we saw from liability-driven investment. It was very profitable until late last year, when it ceased to be profitable and suddenly became very unprofitable and brought with it some rather unfortunate experiences. Now, my question is, given the interest rate risk is not a valid risk with respect to the alternate pensions, is it legal to hedge it? Surely that is a breach of fiduciary responsibility. Now, let's go on. There are two sets of instruments which are basically used in liability-driven investment. The first is borrowing, and this is the law on borrowing. Basically the IORP 2 directive says that IORPs are prohibited from borrowing or acting as a guarantor, and can only borrow for short-term liquidity purposes. The translation of that into English regulations is as I show below. The must not borrow money is rather strange, but there we are. The borrowing that has actually taken place, the explicit borrowing, and there was some 200 to maybe 220 billion of such borrowing outstanding at the beginning of this year, was in the form of repo. Repo being the sale of a gilt or the sale of a security now and its repurchase a short period forward. Now, repo is economically secured borrowing. It effectively subordinates the interest of scheme members. It's used all over the place in the market in LDI. The repurchase leg clearly satisfies the implied test of borrowing repayment from the scheme's assets. Schemes have been borrowing for long term, so some of them have been having liabilities on their books for as long as 15 or 20 years. Now, ICMA says the principal use of repo is secured borrowing. Well, it's not actually secured borrowing, but it's borrowing. TPR bluntly state, we understand repo is structured in this way. Now, in the submission we made to the Work and Pensions Committee, not industry and regulators, we made the suggestion, even if it is legal, there is reputed to be a legal opinion that repo is not borrowing. We accept it is not secured borrowing, but that does not mean it is not borrowing. Even if it is legal, why is TPR ignoring the intent and purpose of that no borrowing requirement? Okay, that's a question. The Bank of England calls repo borrowing. TPR has on occasion claimed that repos are derivatives. No mainstream text does that. A derivative contract, according to EMIR, is a financial contract linked to the fluctuation in the price of an underlying asset or basket of assets, and repo doesn't satisfy that. Repos are not derivatives of the underlying, they are rather operations on those securities, their sale and repurchase. The PPF did at one point in one of its documents referred to repo as derivatives. When I queried that with them, they removed that from their documents. Now, the law on derivatives is quite simple. This is the law as far as the IORP directive is concerned, and it is this directive which was transposed into English law. It was transposed as this. Maybe we would say it as far as they contribute to a reduction of risks. The European law, of which this is meant to be a transposition, limits those risks to investment risks. And this is rather important because these repos and various other derivatives are being used to hedge liability risks. The other thing, of course, is they have also added the further sentences below there, rather a lot more wording than was contained in the original directive, of which this is meant to be a transposition. And our belief is that those words which were added would be struck out by a judge in interpreting this law, and moreover, that the word investment would be written back in. We would love to hear from any of the lawyers present if we are wrong in that belief. Understand that neither Ian nor I are legal scholars, so we'd love to hear from those who are. The legal risks are as follows. Schemes are borrowing heavily. Schemes are hedging liabilities with derivatives. Schemes are hedging illusory risks with derivatives. Schemes have become short-term market-sensitive institutions. If you do a swap where you are a pension scheme, the swap you are doing is to receive long-term fixed rates and to pay the short-term variable rate, usually 6 months SONIA or whatever. It's not SONIA, but you know what I mean, the old 6-month LIBOR. Now, that means that what you've done is just take a stable long-term savings institution and turn it into what is effectively a short-term oriented corporate bank. And of course, your liquidity calls are going to arrive in precisely the times when markets are stressed. And what's more important, or what is as important, is you're not getting paid for it. Schemes are buying assets which actually increase the cost of provision. I didn't cover this in the earlier parts as I omitted that slide, but schemes have bought an awful lot of index-linked gilts at returns which are as low as 3.2% below inflation, below retail price inflation. That can only increase the cost of provision of the pension. It's then the borrowing and derivatives contracts which generated the collateral calls, and those calls were not well managed. The Bank of England and Sarah Breeden were absolutely correct in that. And once you get those collateral calls, distressed selling will follow. And they do this at a scale which disrupts the market. And let me just explain the scale of this stuff in the market. UK pension funds own about 25% of cash gilts. The Bank of England owns about 30%. In addition to that, the UK pension industry controls about another £2.5 trillion of gilt-referenced interest rate swaps. So the total exposure of the UK pensions industry to the gilt market is a little over 1.5 times the size of the market. We've seen that before. We saw it with the insurance, with portfolio insurance in the 1980s, and we saw it in spades with the mortgage crisis in 2007-9. Trustees really should be aware of the risks, and as far as we can make out, most of them are blissfully ignorant. So too should LDI managers, because the law extends liability to their operations. having had the mandate from the trustees, is not sufficient to protect them, and nor will any of their get-out clauses. And more importantly, the pensions regulator must explain why it is encouraging all of this and not enforcing the law. Why did LDI catch on is the important thing. LDI was a very long period in the gestation. The first transactions probably took place around 2002 with Friends Provident, and they didn't really take off until 2008-9. And this shows you the reason why. That is that short rates as the solution to the mortgage crisis, or the extension of the mortgage crisis, were deliberately lowered to almost nothing. Gilt rates fell a little, but not a lot. But there was the better part of 400 basis points of carry trade. So by borrowing short and buying gilts, you were assured a 4 percentage point carry, which is enormous. That is what motivated the blossoming of liability-driven investment. And after a while, it gathered its own momentum. One could then begin to say, as an investment consultant to schemes, well, everyone else is doing it, you should too. And I'm afraid to say the pensions world seems to operate on that basis. Case can be made that the pensions regulator did not understand LDI, did not understand how to regulate DB scheme funding, did not understand the difference between paying benefits when and as they fall due and a valuation deficit. They actually proactively and naively encouraged the embedding of systemic risk. I don't think they were aware of it, but by suggesting to people, and they have been suggesting forcefully to people that they should be doing LDI, they have destroyed a stable savings institution and left us with something short-term and highly volatile. We also think that they did not understand quantitative easing, because one of the things that happened with LDI being exercised was, alongside the Bank of England buying gilts, we also had pension funds. I mean, Bank of England's QE strategy was very simple. They would buy gilts, and the investors selling gilts to them would invest in other more productive assets, equity and infrastructure and all sorts of things. In fact, what we actually saw with LDI was pension funds selling other assets in order to buy gilts. That is something I think that they have to answer for to the politicians. They have encouraged and supported the introduction of leverage to deny that repo is borrowing is the outright bold encouragement of borrowing. They have actually encouraged and supported the introduction of rollover risk in respect of repos. One of the things which has largely gone uncommented on in the course of the discussions of the crisis is there was a mini crisis also in the repo market. And a number of pension funds have told me that they had maturing repos during the period of crisis, and they could not get a price quoted to them at all. As a consequence, we have seen destruction on a huge scale. LDI has done something of the order of £500 billion worth of damage to the assets held by pension funds this year. And this is our overall take on the situation as concerns most people. LDI was understood by very few people, although it was used by very many. We think that most of those people simply did not understand what was going on. And I'll leave it there.
With that positive final note and that very good cartoon, we move on to the discussion, and Bernard Case has some slides which Florence will
follow on with Con to say that I too am not a lawyer. I am a pensions economist, or have sought to be and have been one for a lot of years. So I'm going to be careful about what I say about the state of the law, but I am interested in that dimension of the problem as well. Right, whilst the next screen is coming up, what I'm basically going to talk about is what is LDI as I understand it. What did LDI become? How big was or is the problem that was generated, and who should have been regulating the matter? Con and I have known each other over quite a lot of years, and we agree on some things and we vehemently disagree on others. And I'm partly here to vehemently disagree, but I'm also partly here to agree. Next, please. Right. So I want to say a little bit about what LDI supposedly is. Now, although I've been working pensions for many years, I admit, unlike Con, to have never heard of LDI or never thought about LDI, certainly until about a couple of months ago. And I also think that there were an awful lot of other people who had never heard of it and didn't understand it. But if I look at it very simply, I always understood LDI to simply mean that pension funds' assets should match their liabilities, and that you could call a kind of vanilla LDI. Now, we know something about the way in which pension funds have developed in the UK over the last 30 or so years. We know that in the past, pension schemes, company pension schemes, used to contain a sort of an ambition or an intent to do something. But after the Maxwell affair, beginning of the 90s, I think, this changed an awful lot, and intentions became contractual obligations, so that the notion that assets matching liabilities therefore became very much more important. Connors said something about what the liabilities are there for, and I entirely agree that they're actually there to pay a fixed income stream in the future. That, according to UK legislation, is now indexed into the bargain. And in order to match assets with liabilities, you need a discount rate to discount the liabilities. And I regard the corporate bond rate as being the appropriate rate at which discount, because effectively the company is doing the equivalent of making bond-like promises and obligations. And that, it seems to me, is what is understood and has been understood for quite a long time by bodies such as the Pensions Regulator and also the International Accounting Standards Board, and how its provisions are included into UK understanding. Now, the consequence of all this is that assets need to match reasonably well what the liabilities are. And actually, to achieve what Con talked about, that thing which is going to happen in 40 years' time, which is effectively the guarantee that the pension is now making, is actually something which is rather difficult to do. It is very expensive. It is very expensive to purchase insurance on a put option a long way in the present. It's so expensive that in fact nobody can and will do it. But what this means, if you are going to engage in assets which do match your liabilities, is that it is not wise to engage in what are called growth assets. And here is where I disagree with Con, to meet those future liabilities. It is true there is a path, but there are ups and downs on those paths. And it is the ups and downs on those paths, and the possibility for single large losses to occur, which makes buying any insurance on the long term very, very expensive. And this means making promises is a very expensive matter now. Maybe you should never make these promises. Maybe you should get out. This is why pension funds are getting out of defined benefit plans. Pension schemes, pension sponsors are getting out of defined benefit. It means that there are a whole lot of things, as far as I can see, which if you were simply trying to get your assets to match your liabilities, you shouldn't do. And one of those might well be, and here we disagree, avoid investing in equities, therefore investing in this thing called UK PLC, probably avoiding investing in infrastructure. All those things are not possible, but a vanilla LDI could involve you engaging in interest rate swaps. It could involve you in engaging in currency swaps, but these are very vanilla products. Next, please. Next one. So, right. What happened then is that LDI became something more than this vanilla. It became this very complex leverage product. And what I could see going on was borrowing against, so this is exactly what Con was talking about, gilt holdings to invest in these growth assets. This is what was going on. I am a member, a retired member of the University Superannuation Scheme. If you look at that, that's a classic example of somebody trying to do precisely that. And that was actually one of the reasons why there was pressure on the chief executive earlier on this year, which possibly also led to the chief executive. The trustees of USS got a bit worried about the leverage that USS was engaging in, the level of gearing, and they were concerned about that as an approach. What we saw as a result of the mini budget, the rocketing of gilt rates, this has all been described by Con, the need for collateral calls as a result of that, and the fire sale of some kind of assets, the doom loop and so forth, that people started to write about. At the same time, I mean, there were other things going on. So actually pension schemes looked like they were in a relatively bad situation because equity markets were getting down as well. Commercial property markets were also going down. So things did not at the time, and certainly at the time, did not look very good. But, and here is the but, gilt rate rises have, as far as pension schemes are concerned, and pension schemes are pension schemes, they are not the company, have a positive impact. The discount rate in the UK has moved quite dramatically. Those figures I'm quoting are the figures which USS uses when it's reporting. So these discount rates going up quite a lot have had quite a substantial impact on the liabilities of UK pension schemes. And this means that actually netted all out, the situation is nothing like as bad as some of the doomsayers were actually saying at the time. Because remember, it's all about assets and liabilities matching. So whatever's going on one side is also to some extent going on the other side. And that is certainly what occurred. Next, please. Now, this is where I get into the real problem. Nobody actually really, and Con was right, nobody really knew what was going on. I put in some evidence to the Work and Pensions Subcommittee under the title, is it a whale or a minnow or a fugu? Now, you understand about whales and minnows, but not many people know about fugus, but they are that little fish which Japanese people love to eat, and if it is not prepared properly and something is taken out of it, then eating it will kill you. So it is small, it is very dangerous. How big was the issue? And here, nobody seemed to have a real clue. There were estimates being chucked in of £1 trillion, £1.4 trillion. And I've said that, so how does this compare to defined benefit fund liabilities? Well, it's an awful lot in relation to the PPF liabilities of UK defined benefit funds. But those are the numbers which the Bank of England, the Investment Association and so forth were throwing around. And at best they could say, oh, this is a guesstimate. We had another guesstimate at the Work and Pensions Commission, and Con has repeated it again, of £500 billion in this year, and he repeated this in this year as a result of LDI being lost. Now, those are very large sums relative to the size of UK pension funds. We're talking about 1.5 trillion worth of assets and liabilities approximately. So $500 billion is a third of that. That's an awful lot. That sounds like it's an enormous problem. On the other hand, there are other people who suggested that it was very small, and the Bank of England managed within a matter of a few weeks to move from 1 trillion plus to something like 0.2 trillion in what they called pooled LDI funds. And it said that the pooled LDI funds were the problematic area. It is those funds which were most likely to be open to sudden collateral calls. And that's why I call them Fugu-like. So they're small as a proportion of the whole, but they can be quite nasty in terms of their implications. What actually seems to happen is very, very unclear. But I have talked in the last few days, and I will say this because I don't normally do this. I was talking to Apollo Global Asset Management because they claimed that they bought up about $1.1 billion worth of CLOs from UK pension funds during the post mini budget days. They bought up $1.1 billion, and they said we bought up about a third of what was there. Nobody has questioned this, so this suggests that possibly something like 3 billion, which is a very small sum when we get down to these trillions. So we've got 0.03 trillion. Now look at that number against the numbers at the top, and you actually see that the problem might have been very much smaller than many people talked about. This doesn't mean that when something happened, something nasty happened. But it might have been temporary, and it might have been much smaller than most people were thinking about at the time. Next, please. So this will be just, this is me finishing off. This comes back to the regulation question. And the question here is, did LDI, was it something which people missed out on? Did it fall between the silos, to use the terms of Gillian Tett? I actually read her Silos book as a result of this. I'd heard a lecture about it, but I never read the book, but I did read it. She actually never refers to LDI in it, but it is a classic case of something falling between two stools. We then come back to, and here I sort of, to some extent, I agree with what Connor is saying. I've got a lot of acronyms there. QE2 at LEC and BOE at GSC. Well, I hope everybody understands that this was something which the late Queen said at LSE shortly after the global financial crisis, and she repeated it a few years later at the Bank of England. Did nobody foresee this? And if they didn't, why did they? We also got talks about, sort of events which were several standard deviations apart from what we normally expect. We saw this post or in 2008 when this left people astonished. So we're in the same world of astonishment that we saw back in 2008, except it's about somebody else. Who was responsible for it? Well, you've got the Pensions Regulator, you've got the Bank of England, you've got the SCA at the very least. And he didn't say it here, but he did say it at the Work and Pensions Commission, and he quoted all of these who basically were throwing up their hands and saying, it's not my job. In other words, that's not my responsibility as somebody else, or it's nobody's responsibility. And I do think that at this level, that does look like there is a real failure at a lot of levels. Because, I do agree with Gillian Tett's point of view about silos, and I do agree about things falling between stools. I think that one of the matters which we need to think about here is, who is it who is actually dealing with the advisors, the consultants, the asset managers, and various others who are all involved in the construction of LDI? Who was actually overseeing them? Who does oversee them? And to what extent do they need greater oversight if they led people into a situation such as we might have seen? The question of borrowing, Con was very fluent about this. And although I'm not a lawyer, I follow more or less what he is saying. And I think he was probably right. And if he is probably right, then something did happen which should not have happened. But finally, I come back to the issue of, well, I said it, building nuclear power plants on fault lines in California. We know that we can build nuclear power plants. They are problematic. We saw this in Japan some years ago. We know where we shouldn't build them. We actually continue very often to build them. And I know that Con, when he submitted some evidence to the committee, actually described some of what he was viewing as a seismic shock. And he was, I think, talking about people who were interested in earthquakes then. So we should avoid earthquakes. We shouldn't do silly things. There are things which we do not understand. We fundamentally, it seems, do not understand. And the value of this presentation and Con's presentation is that there are an awful lot of things which we don't really seem to understand. That an awful lot of people got terribly excited. They might have got more excited than they should have got excited about. And we need a lot more clarity than we have currently got. So I hope that this matter doesn't disappear simply because we're not talking about it 3 weeks down the line. We should continue to talk about it. We do need it, I think, better overseen than it is at the moment. And there are a variety of people. I think we should concentrate on having it better overseen. Thank you very much.
Thank you very much, Bernard Casey, for that wonderful and very clear explanation. I like the sentence, building nuclear plants on fault lines in California. It seems to me that one deals with pension funds as well as when one deals with banks and the regulation, there is a very clear public interest at stake. And it seems to me that the phrase building nuclear plants on fault lines in California perfectly encapsulates the excessive risk that was allowed to continue. So we start now our Q&A. We have a very short time. I don't know if Charles Goodhart, who is with us, would like to make either a question or a comment. And if so, Charles, you can just ask because there is open Zoom, so we don't need any permission.
Okay, thank you. Can you hear me?
Yeah, we can hear you very well, Charles.
My questions really relate to where we go from here. And both Con and the discussant have really talked about what has happened. Con began by saying much of the problem was due to change in accountancy methods, whereby everything was marked to market, to today's market prices rather than longer term averages. Is there any possibility that the accountants might change their procedures? Then again, the next point is clearly the worst aspect of what was done was that it wasn't so much hedging as leverage, taking on leverage. And this is clearly a form of borrowing. And the question for the lawyers is how and in what way can the law now be changed to make it clear that taking on leverage is borrowing and the pension funds shouldn't do it? And the third question I've got is exactly who is being harmed. I think the answer to that is the corporate sponsors have actually been harmed. And what kind of recompense can they get? Is it possible for a corporate sponsor who feels that he's lost considerable sums as a result of this to sue? And who would he sue? And is there anyone who is legally liable in any way in a court of law? So those are my three questions. One comment I would make is I think that economics have come out of this sort of without being mentioned. And to some extent, I feel that the LDI was a first cousin of the macroeconomic mainstream view that interest rates were going to be lower for longer, and that length could be almost forever. And therefore, you never needed to worry about interest rates going up significantly, which of course turned out to be wrong. So that's all I've got to add.
Thank you very much, Charles. First,
can I come back?
And then, yeah, Con.
let me respond. I'll respond to both Bernard and to Charles. Actually, on the first point, I can do both with one stone. Bernard is in favor of assets equaling liabilities. I am indeed in favor of assets equaling liabilities, but among those assets must be counted the scheme sponsor. Recourse to the scheme sponsor is meaningful, and it is in fact the scheme sponsor who determines the original terms on which these contracts are issued. Can we change the accounting? Well, we don't actually need to change the corporate accounting. It is sufficient to interpret the existing legislation with respect to scheme valuation such that the sponsor and recourse to the sponsor is recognized as an asset of the scheme. That then alters the discount rate and its variability and resolves almost all of the problems that arise. Will the accountants change away from their AA corporate bond? It's most unlikely. It's also completely insane. I mean, that rate is more volatile than gilts. It contains credit spread compensation and idiosyncratic risk compensation. It just made no sense whatsoever to do that. Bernard seemed to think that companies had no business issuing long-term promises. I'm sorry to say, they do it all the time. They're known as corporate bonds. There are rather a lot of them in existence. Actually, arguably at the moment, too many. The problem specifically of the LDI meltdown was indeed leverage. The Bank of England's interpretation there is right. There are a lot of people saying that the solution to the leverage problem is to introduce larger buffers. Schemes were using stress tests of 100 basis points as their measure of the riskiness of their positions. These are exercises in comparative statics. What we just saw was a 37 basis point move in rates in the 15-year rate, which triggered the spiral. And this was with schemes who are supposedly stable and sustainable under 100 basis points of stress. The comparative statics are useless. We need modeling, which is risk dynamics. I will also add there's another aspect that we need to consider in here, which is the degree of concentration that pension funds have had in these markets. The index-linked gilt market, for example, not only did it go to insanely high prices, the 2068 index-linked bond reached a high of 334 last December. In the crisis, it changed hands at 43. I'll leave you to work it out. It's over 85% decline. The Bernard's numbers, Bernard, you're being disingenuous. We sent you lots of explanations as to how we arrived at our $500 billion estimate. That is, in fact, the estimate since the beginning of the year. And scheme assets have dropped from about 1.85 trillion at the beginning of the year to about 1.15 trillion now. And of that 700, about 500 is due to LDI. The Bank of England did indeed say 200 billion of assets in pooled funds. But the important thing about those pooled funds is they are 4 times levered. That means those funds, in fact, control £1 trillion worth of gilts. And that's what created lots and lots of the mayhem at the beginning of the crisis. So let's not dismiss LDI funds, pooled funds, as an irrelevance. One of the problems is that LDI funds can use derivatives and can borrow, just like any mutual fund. So if we were to put constraints on schemes, then we have a problem because there is an obvious escape hatch in the form of LDI funds in some form or other. The final point I will make, what do we do? Well, sorry, who was harm done to? Well, there's rather a lot of harm being done. Mortgage rates went up rather more fastly than they otherwise would have done. Savers in DC pension schemes who owned any bonds, notably those who were close to retirement and were likely very heavily invested in bonds, saw their pension pots diminish massively. I have a friend who is retiring at Christmas. His pot was down by 30% from the beginning of the year. He has, in fact, entirely reorganized his retirement plans because of that. As it happens, most of it has recovered, or some of it has recovered, but he has committed to going back to work 3 days a week for the next 2 years because he can't afford to retire. What are the solutions? I will confess I'm not sure. I think we need to know more about the effects of concentration on market price volatility and market price movement. And I'll be sending Charles an email asking him for a reading list in that area because my initial searches have been somewhat less than satisfactory. I think we need a lot of work doing on understanding and modeling the risk dynamics before we start writing regulations. And it looks to me as if the problem of creating a model here is extremely difficult. It looks to me as if it will be NP hard. Beyond that, let's avoid the immediate and obvious knee-jerk reactions, but I can see that there are a lot of people within Parliament who are very anxious to write some more laws. And that goes against the grain with me because I've always believed in less rather than more. On the other hand, if we have a set of actions which risk destroying our gilt market, that cannot be tolerated. I'll leave it there.
Thank you very much. Probably, I don't know if Bernard also wants to add anything to it.
I'm just going to be very quick. I agree with some of what Con said. I agree with some of what Charles said. I mean, I think that the accountants, I actually stand closer to accountants than I maybe normally would do. And I come with respect to that to something which Con said. He said to me, companies shouldn't make promises. I said they shouldn't make promises with respect to pensions if they can't afford to keep them. And that is why they are not making DB-like promises anymore. Companies do make long-term promises, Con said. They issue corporate bonds, as far as I'm concerned. And like it or not, the DB pension system, as a result of regulations and laws 30 plus years ago, have become bond-like obligations. So I can't see the difference between one bond-like obligation and another. And therefore I stick to the appropriate discount rate. And if a company issues a corporate bond today, it's different from one that it issues tomorrow. But the principle is the same. So I stick very much to that. I agree that the problem has been leverage. How big this issue is, I mean, Con and I can sit down and sort of debate this because we don't quite know how much happened, where it happened. We know that something might have happened and could have happened, but if I follow what Apollo says to me, it didn't seem to be on a very large scale after all. So that in the greater scheme of things, yes, there were hiccups, yes, there were some poisonous results, and possibly somebody did have to postpone their retirement, but I'm not quite sure how many knee-jerk reactions that were. After all, if the pension fund of the mate of Con's got better now, nevertheless, he seems to have committed himself to working 3 days a week for the next 2 years. So I think that there is who is actually been hurt by this. I think some people have been shocked by this. Who can be, whether, as Charles suggests, people can be sued for it, and I'm not quite sure who we might be suing. I'm always very in favour of suing advisors and consultants, most of whom I think are actually simply there skimming large amounts of money off what could be a very simple, straightforward product. Hence, I go back to my vanilla LDI. That should be a very simple product which operates with very little intervention in it. Once it is running, it runs along. It's a bit like retail banking ought to be. And there are all the implications of, sort of relationships between retail banks and investment banks, and how these things should be kept apart, and a whole lot of discussions also about what bankers should be get paid and what investment bankers maybe should get paid and what risks they take. And I would apply quite a lot of this to the people whom I think are primarily responsible for getting us into some sort of mess. But I'm still wait to be convinced that this is a huge mess. I think it revealed to us that there are issues there. I think it revealed to us that there are points where regulators need to take a second and a third look. And I think, and I hope that they will take that job seriously. And, if what we have said, whether Con and I agree or disagree, helps that process. And if this seminar helps that process, then we've done something a little bit useful.
Could I just come in and offer you a couple of numbers, Bernard, on how big was it? In the week ended the 30th of September, the main week of the crisis, the gilt market turnover was 14% of the outstanding stock. That's more than twice its normal daily turnover. 264 billion pounds worth of gilts changed hands at an average of lower prices. If you then look at what else went on, the Apollo is very interesting. It's CLOs. The total holdings of CLOs across all pension schemes was probably no more than 20 or 30 billion pounds. So if they bought 1.1 billion, they bought 3 or 4% of the outstanding. That is a trivially small area. Sales of overseas securities were sufficient to buy sterling. I spoke with one of the major sterling dealers, and he told me that he had bought upwards of 25 billion pounds worth of sterling, selling euros, i.e. these from pension funds. So the pension fund was selling euros, having liquidated its European equities in order to repatriate the money here. This was one of the reasons that the exchange rate, rather than being soft and going down on the Tuesday, Wednesday, Thursday of that week, in fact rallied. The size of this was extremely substantial.
Well, you see, I don't know, and I really don't know. There were lots of things going on. People were selling out of sterling because they were frightened. There were lots of things going on, but the CLOs were typically the things. This was the stuff people were.
CLOs do not figure in the universe of pension scheme investments in any meaningful way.
This is not my understanding. It might be your understanding. And I think, and I'm not, what I think we do not know, and what I would like to know, is what was really going on, where it was going on, and why it was going on. And I do think that we might be in a situation where we're attributing an awful lot of other things which are going on as a result of that mini budget, an awful lot of other things to the implications for defined benefit pension funds. So I think, I would like to stand back, and what I've tried to do is to stand back and try and find out what is happening. And what I fail to be able to find out from anybody, I've asked the Bank of England, I've asked the FCA, I've asked various people, I wrote to them and I said, what do you understand by these numbers? Where do you get these numbers from? What are they about? And they said, well, we don't really know. I mean, and I have emails from them that says, this is our best guess. So I think we are working in the dark. And I think it is incumbent upon a lot of us to try and work through and to try and shine a bit of light on this. I'm not saying it was good, I'm not saying it was bad. I'm saying something happened, but I really don't think we know enough about what happened. But we do know enough that there is something going on in pension funds, and Con and I think, agree about this. There is something going on in the way in which pension funds are being overseen or not overseen, where perhaps we ought to devote a bit more attention to make sure that we don't get into that kind of situation. That's where I would leave it for the moment. But, you know, I think there is a call for some serious investigation, and TPRs, BOEs, FCAs, and various other people, it is incumbent upon them to actually start doing this work and not coming back with estimates.
Bernard, that serious investigation is just what we've been doing.
I have to. I hope. So, you know, kind of, we can compare notes about that sort of later. But I think, you know, and it's not, it shouldn't just be semi-retired academics like me and semi-retired fund managers like you who are having to take the responsibility for doing that. I mean, good for us for doing it, but I think, you know, there are people with far more resources.
Ian's very much an active academic. He heads the international side of the business school at Leeds.
We will see.
Thank you very much. I think, I mean, it is very interesting to hear you, and also thanks to Professor Clacher that is not here, I mean, that has contributed to the paper with Dr. Keating and Professor Casey for your brilliant discussion. I think generally, I mean, one of the main intake that we can have during this discussion is that essentially risk and uncertainty are dominating the market. So markets, sometimes they are dominated by uncertainty, and I think it is something that you as economists, you know even better than me, that I'm just a lawyer. But uncertainty, I mean, are those events that we cannot predict. And so if there is no prediction, we need a solution, and this solution can sometimes come from legal perspective. So one idea, and you already discussed a little bit at this point about liquidity buffers. If we can increase liquidity buffers, and if this can in some way provide a liquidity collateral for the future crash, if there will be any.
Okay, Daniel, let me just explain the problem with liquidity buffers.
Yes.
Both the CSSF in Luxembourg and the Central Bank of Ireland have indicated that they will be requiring pooled funds to hold 300 to 400 basis points of liquidity buffers. In fact, they both indicated the higher end of that range, so 400 basis points. It's fine to have a buffer of 400 basis points. The problem comes that if you are required to hold 400 basis points of buffer, as is how they are talking, then you know a collateral call comes in. You meet it by delivering part of the collateral buffer to the counterparty. And then, of course, you've got to replenish your buffer, which means you've got to go and sell securities in the market. Now, it doesn't matter how big your buffer is. If you've got to sell to replace that which has just been used, you are in no better position with 400 basis points than you were with 100. And they seem to have missed that point entirely.
Absolutely. I mean, this is the point of discussion, in fact, that we had.
Yeah.
And just for the sake of time.
That's what I mean when I say it's very expensive. I mean, maybe we do need, but if we're saying we need these very big buffers, it is because something is going on that we need to be buffered against. And maybe we shouldn't be doing those things that we need to be buffered against. And that's what comes back to my point about, you know, sort of, if you're going to make big problems, promises. Like
we should stop here. We agree.
Absolutely. that is the point.
You agree somewhere. Yeah.
That in some way is a good point that we discovered today. So just for the sake of time, I think we need to call this conference and call the day, because it's 20 past 8, sorry, past 6. And I want to thank you again, I mean, to be here, and all the audience that was joining us